All right. Hey, good afternoon, everybody. This is Carter Schoenberg with Soundway. With us today, we have Eric Crusius. So many of you in the CMMC ecosystem may be familiar with Eric, but if you are not, Eric recently changed firms, and I'm going to go ahead and turn the floor over to Eric so he can give his bio for everybody and learn about the subject matter expertise that he's bringing to the table. Eric, over to you.
Thanks, Carter. Yep, as you alluded to, I'm now chairing the government contracts practice at Hunton Kurth, a large firm with offices around the country. I sit in the DC office, of course, where the center of it all is, especially with the cybersecurity risk assessments that are taking place at the Department of Defense as we speak. So I've been practicing law for more than 20 years. I guess it's about 25 years at this point. And I joke now that my law license can now legally drink. So it's fun times here. But I have a full service government contracts practice, but I also really concentrate and have taken a deep dive in the cybersecurity space as it relates to government contracts. And I've been doing that for about 15 years now. And really kind of investigating kind of ways that companies can better protect their information and avoid cybersecurity risks. Of course, thinking about the different government regulations that have come out and requirements and how contractors and their subcontractors can approach those. Because the goal, of course, is not to, I always try to get to yes, like how can we accomplish something? How can we get it done, even with these requirements and regulations in place? And sometimes they're for the best and sometimes they act as a roadblock, but we always find a way to kind of get to yes. So Carter, really pleased to be joining you today and having this discussion. So thanks for inviting me.
No, it's a pleasure to have you here. And I love how you're helping set the stage for today's session, talking about cyber risk, because for today's session, obviously as title, we're going to be focusing on CMMC. And while CMMC is a critical component for upping the game for the supply chain as it applies to the U.S. government, from a C3PAO's perspective and on the consulting side, one of the things that we are continuously seeing is this misunderstanding of, if I achieve this, then that's it. That's the ceiling. That's all I ever have to worry about. And unfortunately, that's really, really far from true. And this isn't to sit there and say that, CMMC isn't a great thing. It's just for context, and context is king. You have to understand that what we have here is going to be defined as CMMC is not the Safety Act. And for individuals watching today's sessions that's not familiar with the Safety Act, we'll be going into that in greater detail. So why don't we go ahead and get started with this? And as it applies to CMMC, again, this is something that started back in 2019. It was just recently ratified almost 4 months ago now, for 32 CFR Part 170. And that basically established that the program for CMMC is living. It's about to be fully ratified under this most recent congressional session, and we are waiting for 48 CFR, which would then be basically the DFAR supplement for 7021, which then obligates the Department of Defense to have this type of language, a CMMC obligation based on a level of 1, 2, or 3 in all contracts in a phased rollout. Phase 1 is actually currently live right now at level 1. Level 2 would be subsequent to the ratification of 48 CFR, as well as for level 3. I think it's also important for viewers to understand that at least as of March 28th, there were a total of 64 C3PAOs. And the reason why I bring this to everybody's attention is because of the fact that there is still a presumption of organizations have time to be able to get their ducks in a row. And from at least what we are seeing at Soundway, and having spoken with a number of other C3PAOs and lead assessors, the majority of organizations don't have their ducks in a row. And even if they do, there's probably a miscellaneous pigeon mixed in throughout those ducks. So it's one of those kinds of challenges that creates a beast of burden and understanding just how much actual time do they have. And I'd love to kind of get your take, Eric, from what you're seeing on the clients that you represent with respect to post December 16th and post January 2nd when C3PAs went live. What is now the risk appetite of the clients that you're currently supporting?
It's a great question, and a ton to unpack, of course. And what I'm telling clients in general is that you have a new administration. There's always a risk that CMMC may change because of that. But we have to remember that this program started under the first Trump administration. So, like you said, started way back in 2019. And the folks who helped lead this during the Trump administration first go around are now back there. But the risk is always about kind of the controls that form the core of CMMC. Because at its base, CMMC is just a verification program. It's not directing, except for level 3, it's not directing compliance with new controls. So when you think about it, it's NIST 800-171. If you have controlled and classified information, is what you have to comply with, and the 110 controls in there. And that's what's getting verified as part of the CMMC program. Again, if you have CUI. And what I tell clients is CMMC may change, right? There may be a different wrapper around this thing. It may be more complicated or less complicated. It could potentially go away at some point, although that's highly unlikely, I think. It doesn't matter really, because there is a risk of non-compliance with NIST 800-171 because that is a current requirement if you have classified information. The DFARS 252, 204, 7012 clause has the requirement in there already, and it's had it for years. And DoD's position is we expect you to comply with it now if you have contracts. So, from a risk appetite standpoint, which I think is a great question and observation, it's the fact that it's risky not to comply at this point because DOJ is looking at these things still. There was just a settlement that came out recently during the Trump administration, so it shows that they're still pursuing these things. DOD, of course, has told their contracting officer base, look, if they're not compliant, don't award contracts to them, or don't, inquire if you're worried about compliance. So I think the riskier part about this is non-compliance at this point, and I think companies are having less of an appetite for risk. And one other observation too, is that the C3PO program, where you have a third party come in and do the assessment so you can be certified under level 2, that is a great risk reducer. It's not like your title said, it's not like the Safety Act where you have no liability if you get an assessment done. But it does certainly lower the temperature and lower the risk that companies face because you have a third party coming in and saying, hey, they are compliant with these government mandated controls, at least on that date when the assessment takes place. The next day may all fall to pieces, but at least at that time, there is an assessment done that has been affirmed compliance with those 110 controls. So I see that kind of as a way to minimize, but not eliminate, but minimize the risk that companies face.
Eric, one of the things that you just made reference to, and I want to kind of pull on that thread a little bit with respect to the government telling its KOs and its COTARs on what they need to do and how they need to go about doing things. So one of the DFARS clauses, 7024, actually gives the contracting officials the right, not that they have to, but the right to actually use a government contractor's SPUR score as an evaluation criteria. Have you, by chance, had any clients in the past several years since 7024 has been live that had any kinds of challenges with respect to they submitted a score, maybe it was subsequently challenged by DIBCAC, and as a result of that, it put their potential contract vehicle in harm's way?
I haven't had that exact scenario, though I've heard anecdotally of that happening, but not to my clients. I've heard of a number of things, though, with respect to SPUR scores that I think are really interesting. The first is I actually had a protest about 2 summers ago, 2.5 years ago at this point, where, Carter, you may be familiar with this case, but where the awardee did not submit a SPUR score. And we discovered that when looking through the record during the course of the protest and added a protest ground because they did not submit a SPUR score. And GAO came in and said they were not eligible for award because they did not have a SPUR score when the 7019 and 7020 clauses were in the contract. And that meant, now we didn't win that protest for other reasons, completely unrelated to that, but the GAO said have to have a SPUR score if that clause is in a contract. So that's a risk factor right there. And then you kind of look at the Georgia Tech case, False Claims Act case that was brought by a whistleblower, and now the government has intervened and is bringing that case. That basis of that one of the basis of that case is an incorrect SPUR score that was entered by the university, allegedly, right, by the university into the supplier performance risk system database. Now, what the allegation is that the university knew was false, and they still entered it anyway. The score didn't reflect anything that the university was doing or not doing, which I thought was kind of interesting. But again, it's just an allegation, right? So the university has a chance to defend itself and deny these allegations and show that the government is kind of completely wrong about it. But that's another kind of bullet point with the SPUR score and how important it is. And then the kind of the last thing which you've talked about is the 7024 clause, which I think is a fascinating clause, 252, 204, 7024. I have had a couple of protests dealing with the 7024 clause. And in fact, I just won one a week or two ago, not related to the SPUR score, but related to other things that clause requires. It's I think there's a complete lack of appreciation in the contracting base, how that is a multifaceted clause that requires contracting officers to do a bunch of things before they award a contract. One of them is to look at the risk assessment of a contractor. And one of those things, of course, could be, are they compliant with the cybersecurity requirements, and other things like, have they delivered on time? Do they have a risk of counterfeit products that they're providing? Things like that. That's one of a number of things. They also have to look at, does the price create a risk to the government that has to be mitigated, or is it consistent with historical prices paid? That's another thing. And then the other thing to look for, if supplies are being provided, are these supplies the kind of supplies where we've had issues with them in the past? So that clause kind of has a lot of moving parts. And what I've been finding, at least in my practice so far, is that the contracting officers or the folks who are evaluating proposals are looking at one of those things, but not all of them for whatever reason. Because I think it's most FAR clauses and DFARS clauses have like one goal in mind. You're going to do this one thing. Even the 7012 clause, it's like you're going to protect the information, right? And then there's some offshoots off of that. This clause has completely, seemingly unrelated things in it, although there is a common tie to them, and that's making sure that whatever contract is awarded will be performed because the contractor is responsible. They're providing the right products at the right price, or services at the right price. And I think there hasn't been adequate training on that clause, and I think you see, at least I'm seeing, folks are getting caught up in it, and it's not being interpreted the right way, and that's leading to a lot of kind of issues in the contracting process. And I think there's also a lot of confusion because all this stuff is happening in the supplier performance risk system, which is the same system you put in your 800-171 score. So there's sometimes a conflation between the SPURS requirements and this requirement, because they are related to each other, but they're not exactly the same, like as you observed correctly before, Carter. So it's really interesting, actually. And it'll take a little while to get smoothed out. And I don't think a lot of folks are really talking about it, although it's really significantly impacting some fairly large opportunities out there.
So one of the last data points I have on the slide before we advance was the number of actual C3PAs that are out there. Are any of the clients that you or that your firm is currently supporting find it challenging to get on a C3PAO schedule at this point?
Yes. And that's because a lot of C3POs, the good ones, are kind of scheduling things out months and months out at this point. Now, because we don't have the final, you talked about kind of the implementation timeline, and as you said, that the level 2 third-party assessments won't be required for the most part until at least a year after the regulation is effective. So that's giving people some time. But then you have these large primes that are kind of insistent that go get it now, right? Yeah. So there is a challenge in kind of going to get it now, because like you said, have on here, there's only 64 C3POs. Some of them have multiple assessment teams, true. Let's say there are a total of 100 assessment teams out there capable of doing assessments. By DoD's own estimate, there are more than 76,500 companies that will need an assessment in the next couple of years. So that's one assessment team for every 760 companies.
Right.
So inevitably, there's going to be a backlog when that happens, and you'll probably see a slower rollout if that does happen. But I know the AB is working very hard to kind of get folks on board. But there's certainly, long story short, I am seeing a backlog, and that's why it's so important, even if you're not quite ready yet, to get a reservation on somebody's calendar. So that way, in 6 to 9 months, when you are ready, you'll have a spot to go, and you'll be ready for the final implementation of CMMC when it comes out.
Yeah, and I would like to be able to point out for organizations seeking certification, if you are in fact watching this session, there is nothing preventing you from engaging with a C3PO like Soundway or similar, and being able to, as Eric pointed out, at least get on their schedule. Provide the initial retainer, get on their schedule, whether it's 3 months, 6 months, 9 months, 14 months. It doesn't make any difference. But until you can get on their schedule, it is going to be a first come, first serve. So the longer you delay in establishing that initial contractual obligation, logic dictates the further down range it's going to be before they can even agree to assess you at that point in time.
Right, absolutely. And look, when you're going to figure out who, not just who you want your C3PO to be, but if you're doing managed services, who you want that company to be, you want to go with folks who know what they're doing and have been down that rodeo before, who go to these I know it sounds kind of trite, but go to these conferences and participate in them. I don't endorse products or services, but every time I go, I see Carter, and every time he goes, he probably sees me. Sorry for him, but it's an indication that we're both invested kind of in this community and kind of making sure that things are getting done the right way. Because it's, first of all, I find it fascinating, and also it's better for our country that way. So, I think that's a very important thing to do, is to really kick the tires of the C3PO that you're talking to.
So you made reference to the Georgia Tech case, which obviously is falling in that swim lane of FCA, False Claims Act, which we're going to talk about on a later slide. But I just want to kind of like tickle that because, you and I had talked about this previously with respect to when the Civil Cyber Fraud Initiative became an investigative business unit within the Department of Justice, which was within a 45-day window of CMMC 2.0 going live. I think there was a total of 8 attorneys, and now recent information supporting that they have, I think, over 115, which
Wow.
at least telegraphs to me that they are significantly ramping up these efforts because they see some meat to be able to clamp onto. And as a result of that, there's enough of an investment strategy to open the aperture and bring on more investigators and more assistant U.S. district attorneys to vigorously pursue these types of claims.
Yes, I mean, I'm sure, like, DoD's belief has long been that contractors aren't compliant with these regulations. I went to a DoD information session, and they're building off of 395, their complex there. I think it was way back in 2018 or so.
Mhm.
And they had said, or maybe it may have been even 2017, they were talking about how they know that companies are not compliant with the cybersecurity requirements, and there was an anger in the voice of the DoD officials talking about it, like, we're going to do something about this. And certainly that's something that they're doing now with the CMMC program. I think it's pretty clear that they believe that companies are not compliant, and that leads all the way back to DOJ. And DOJ probably views this, I would imagine they would, if they've done any investigation at all, as like kind of shooting fish in a barrel. Like, we could kind of look at any company and they're probably not compliant with the controls, aside from maybe the really large ones and a select few others. So, and they've been taking these contracts on that have the requirement in it. So I think there's certainly a False Claims Act risk there. And if you're in DOJ looking to score some quick points, and this is the way to do it. Not saying that that's the best thing or what they should be doing, but that is certainly an option that they have. And I don't see any indication that the Trump administration finds this any less of a priority than the Biden administration did. They didn't agree on much things, but certainly cyber controls, preventing China from getting our information, is one of those things where they agree. And that's why, we're seeing the fact that the current administration is still on board with CMMC and brought in its architect, you could say, back into the administration. That says a lot right there.
Yeah, I know there's been a lot of fervor, especially in the past week, with respect to certain nominees and what type of impact negative, good, bad, or indifference going to happen to CMMC? And I was just asked this question from a GRC organization. They're like, well, what are your thoughts on this? And it's a very, very simple response. Who's the number one country that pilfers our technology products and intellectual property? Well, China. And are you under some misguided impression that Trump is a fan of China? So, I just don't see it going anywhere anytime soon.
Yes, I agree.
Now, with respect to the title, CMMC is not the Safety Act. So again, to your point, one of the things that, again, we still see with clients, either as mostly with initial prospects, but this conflating of that CMMC is something that I had to do. Well, technically, under the four corners of the contract, you are already obligated to do this. All the CMMC is a third-party way of policing that you're not in violation of the contractual terms. Whereas with the Safety Act, so the Safety Act came back as a result of obviously the unfortunate circumstances of 9/11, and they wanted to create a mechanism to be able to foster the adoption of enhanced security protocols and capabilities. And I'd love to kind of get your feedback based on your background and your experience with the Safety Act.
Sure. And I've dealt with the Safety Act for clients before, and I think that this has a very important distinction, because I think folks kind of get wrapped up into it, is that the Safety Act kind of acts as a insurance policy for companies if they're providing, it's not as broad as people think it is. There's a bunch of hoops you have to drive through in the graphic you're showing on the screen here. I'm not sure if the listeners will be able to see it or not, but whether or not, there are certain limitations, including liability caps to it. But it's still stronger than like having all the controls in place under NIST 800-171. There is still risk involved, even if you have the right controls in place, or even if you've been certified, because having the right controls doesn't mean there won't be a cybersecurity incident. Far less likely, I would argue, that you do, because they'll find a softer target unless they really just want something you have. But there's a lower risk, but not a zero risk, that there's a cyber incident in your future or a ransomware attack. And those things are expensive to respond to. And there are notifications that generally have to be made, especially for DoD right now, and there'll be other agencies soon. The VA, DHS also have their own disclosure requirements. CISA may have that sometime this year, as well as the rest of the civilian agencies. So there are, and those disclosure requirements still come even if you have all the controls in place, right? The controls don't vitiate the need to tell the government that you've had a cybersecurity incident. It may help you post disclosure when you show the government, look, I've been certified and I've been assessed and given a clean bill of health, and I still do all these controls and all that kind of stuff. But that doesn't change the fact that the incident happened. And there's always a risk that personally identifiable information can be leaked, even if you are compliant with the controls. And that, of course, creates its own risk too, because having PII comes with a lot of responsibility. If you have like a VA contract with PII, that comes with its own issues, or even the state breach disclosure laws that impact PII. So, being compliant with CMMC does not act as a protection, does not give you protection under liability or damages. Whereas the Safety Act, in some circumstances, can do that, which I think is a very important difference. I think that some folks miss.
I'd love to kind of get your take on clients that you are currently representing that have business with the defense line of business, but also are supporting federal civilian agencies, and with the pending FAR rule, and what, if any, consternation are they having with you as their legal SME with regards to how do they thread that needle so that way they can demonstrate conformance on both sides of the fence?
Right, and that's a great question. And you have the difficult thing that companies, I think, are having is you have a bunch of pending rules, and we don't know when they're going to come out or what they're going to look like when they do. And I tell those clients, look to the contract. What does your contract say you have to do today? And that's what you have to worry about today. But of course, all these other things have long lead times. So you want to be preparing for tomorrow, what you think tomorrow will look like. But first and foremost, think about today and what's required today in your contract, and do those things. I thought DoD was really helpful in their final programmatic rule, that, as you put out in the slide before, the 32 CFR rule, that had in the past, and under the proposed rule, it read to me at least that you'd have to get, if you have a system that you're going to get assessed, you have to go get a level 1 assessment and then a level 2 assessment. Or if you have a system that has CUI and FCI on it, federal contract information, you'd have to get both a level 1 and level 2 assessment, which would create additional cost and consternation and kind of trying to get these two different standards together. And DoD in the final rule essentially has said, you don't have to do that. So if you have a system that has CUI and federal contract information, which is level 1, then you just have to get a level 2 assessment and you'll be covered under level 1. Essentially, your level 2 gets you your level 1 also. It's like having global entry and then getting pre-check along with it. Like you're covered with pre-check if you have global entry.
That's a great analogy. Are you seeing clients having misgivings with regards to, on the Fed Civ side, I got to focus on Rev 3, but I have basically a dispensation from DoD to hold at level 2 for the foreseeable future. So which direction do I go, and how much time do I need to have to, reacclimate that which was going to be at level 2 to pivot over to level 3, revision 3, I should say.
Yes. And I think it's important to kind of, what I'm telling clients generally, like every circumstance is different, but the general advice is that just concentrate on getting square with revision 2. That's what the CMMC in the first instance will require. That's what the that's what the DFARS rule will require in the first instance. So let's get square with that. And then once we're square with that, let's worry about revision 3. By DoD's own estimate, we're about 12 to 18 months away from revision 3 making its way into CMMC. They are working on updating the rule. And I imagine they're working on updating the 7012 clause also. They are updating the 7012 clause. We know that for sure. But I imagine they're updating the 712 clause to put in Rev 3 in there too. Again, 12 to 18 month runway. Let's get square with revision 2 and then jump off revision 2, unless they haven't started their journey at all yet. Like if you haven't even tried to be compliant with revision 2, maybe it makes sense to just start with revision 3, because we don't know this, but I suspect that that will be good enough. Like you could get assessed under level 3, under revision 3, and have that count. Although again, we don't know that yet because the final rule isn't out yet on the contract rule. So we'll maybe have a better sense then.
So, one of the things that you were just talking about, especially with regards to PII, which I always have found fascinating, because there's, again, some of these misgivings that I think government contractors have with respect to what is obligated under CMMC versus what's obligated under DFARS versus state obligations, if the minimum triggers are applicable, and also the potential downsides of a False Claims Act. Not that I could think there's any upside of a False Claims Act, except for the relator on that one. But one of the things that we're seeing time and time again is, and the best example I can give, because it's a real world example, is, has the organization identified the appropriate authorities to notify? Now, from a CMMC perspective, they can sit there and say the Acme company, or Hunton law firm. I mean, they have identified it, and we have to acknowledge that. But under DFARS, you didn't notify. You're not planning on notifying DC3. Your defines critical infrastructure. So, but you have nothing in your documentation stipulating that you're going to notify CISA as also obligated. And there are a variety of different controls that are not really addressed to the level of specificity in CMMC that are actually being called out in DFARS. And I would love to kind of get your take on what, if any, type of similarities that you're seeing with your client base.
Yeah, I mean, I think a lot of you kind of talk about like incident response. The issue with the current state of incident response, and it's going to continue on like this for a while, is that each incident response requirement, the VA has one, DHS has one, DoD has one, and then there are a couple of FAR ones that are in the works right now. So you'll have, and then there's the one for CISA that is in the works also. And so incident disclosures, all these rules have different triggers. Like what has to happen before I have to notify the government? Is it an information leak, or is it just not following policy, or information like spillage within the organization? They all have different requirements about who to tell about the incident.
Mhm.
They all have requirements about the time frame to do so, and they all have different requirements about what information to provide. So you have a situation where you could run into situations where you have incidents where you're telling multiple parties, or maybe you're not, because one party you have to tell, one party you could keep silent for. So I think that's kind of, and that makes the company less able to respond effectively to the incident, which is unfortunate. But we haven't seen a willingness from agencies to kind of defer to each other, saying, "Hey, if you just respond to one, that's good enough for us," because they all have their specific information that they want. I think one day we will have one central clearinghouse within the government that if you have an incident involving government information, whether it's PII or CUI or whatever it is, you are going to just go to this website and disclose, and it'll be circulate, and you check boxes with which agencies you're involved with, you have contracts with, or were involved with the incident, their information, and it is automatically fed to those agencies. I think that simple process will happen, but it probably will be at least 5 years before it does, because
Sure.
we don't have agreement among the agencies on what that looks like.
With regards to state obligations, and in fairness, the majority of government contractors are not of the size where either their existing employee base reaches a certain numeric value that would create the trigger, or maintaining enough PII records on behalf of the government to also stipulate a trigger. But if you're a larger, let's say a larger system integrator, whether you're Raytheon, General Dynamics, Parsons, whatever the case may be, can you think of any examples where clients, and obviously not naming the clients, but where maybe that was a little bit of an oversight? Well, this is government, this is federal government, this is what we're focusing on from a breach notification obligation, but not being aware, and as a result of that, not being aware, potentially expanding some of their liability exposure, because they would still have the obligation to notify state attorney generals if the minimum trigger for notification actually occurred.
Right. Yeah, and I hopefully try to quickly disabuse them of that notion. And I've worked with clients who have gone and made disclosures to the states before. Sometimes what they'll do is if you disclose to a lot of them, they'll form a group, so you're only responding to one of the group instead of like 15 people, state attorney generals at the same time, which could be very laborious and not fun at all. Not that anything in an incident response is fun for the company, of course, but I do think that this is an area that's overlooked, especially when there's PII involved. And the difficult thing with these state responses is kind of what you allude to, Carter, is they all have different triggers, like how many records need to be impacted before I have to tell the state, and some of them have different places to tell. Obviously, there are going to be 50 different locations to tell because there are 50 different states, but different positions within the government want to receive the information depending on how the government is set up in that individual state, or how they've set it up to receive that information. A state like New York is very different than a state like Virginia, for instance. So whereas New York, you have, at least as of last I checked, you had multiple places you had to tell depending on the size of the incident. So those state responses can be very important, but they're, like you said, they're often overlooked when PII is involved.
Well, I know we're kind of getting at the end of the time, but I would like to just kind of like wrap up with regards to talking a little bit further about the False Claims Act. So sometimes this kind of comes across as a FUD tactic, but forgetting the fear, uncertainty, and doubt approach on this, would you just mind restating for those that are attending today's session what all is encompassed on what dictates a False Claims Act, and what type of special and punitive damages can be inflicted on the offending organization?
Yeah, and I'll start by kind of saying this whole talk about False Claims Act does get a lot of talk in our community, but it's not without merit, because we're seeing cases now being settled where the initial claim was a claim under the False Claims Act. And a lot of times, those False Claims Act cases are not brought by the government in the first instance, but by a whistleblower within the company. And the whistleblower is alleging that the company doesn't have the right controls in place, or whatever it is related to the contract performance. And this is not legal advice, but general standard is, was the company reckless? Did they intentionally do this? not just mere negligence. It's usually a standard that's a little bit higher than that. But the kind of the level of establishing a False Claims Act case can vary from court to court, so I won't opine on that. But it's a low enough standard where there have been multiple companies that have gotten caught up in this, and I tell clients this all the time. Look, most whistleblowers don't wake up wanting to be a whistleblower. It's just because they feel like they have no choice at that point in time. So it's really good to kind of instead is to really take their concern, review their concern, and address the concern, right? Not just say, no, get out of here. It's annoying sometimes to address concerns you don't think have merit. But if you kind of look at it and take it seriously, more often than not, they will not become a whistleblower, right? Because they will have felt heard, and you will save yourself literally millions of dollars. Because we'll talk about the penalties in a second, but it's also like the attorney's fees, like are not insignificant in these cases. The fees you pay for various experts that come in, review, and the companies that come in and pull records and review records and allow the attorneys to review them more efficiently. And then on top of that, you have kind of the penalties under the False Claims Act, which are around $20,000 per invoice that's impacted. So if you send out 15 invoices a month, right, because you're a good-sized government contractor, that's 20,000 times 15, which is about $300,000 a month in penalties. And then you have, on top of that, you have essentially treble damages. So if the contract is worth $3 million, that's $9 million in damages. So very significant penalties under the False Claims Act.
You know, one of the things, and even if we just table CMMC, in the course of my professional career, where cyber risk management consulting has been at the cornerstone, one of the things that I have always have communicated with a number of clients is, even if you think that you're right, what's it going to cost you to defend your position versus just biting the bullet and making it happen right now? Even just being able to do that cost benefit analysis is usually very favorable versus just saying, well, I'll take my chances, because unfortunately taking that the chances is increasingly, and I would even argue as it's increasing, is becoming more disproportionately stacked against the mindset of, well, I'll take my chances when it happens to me, because the financial implications are so much more acute now than they ever have been in the past 5 or 10 years.
Absolutely.
Well, so Eric, this has been an absolutely fascinating topic. I really appreciate your time and your subject matter expertise on this. I'll keep the floor open for any questions from the attendees, and we'll vet through those as they come through. And if we don't have any, we will adjourn in a couple of minutes. But your contact information is available here. Again, I've known Eric for a number of years. He is exceptional in this field of expertise. And if you have any comments, questions, or concerns as it applies to CMMC, please feel free to reach out to me. And here's my contact information as well. Well, I don't see that we have any comments coming through right now, so we will go ahead and adjourn. If you're watching this on YouTube, please be sure to hit the like button and subscribe, and you'll be alerted to newer sessions that Soundwave will be having in the immediate future. Eric, thank you again for your time.
Thank you, Carter. Thanks for having me.